Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. My name is Roger Gibb. I'm from Mason, Ohio, House District 56. So in 2022, the Trafalgar Group conducted a nationally representative survey of American adults. What they found is that 66% of Americans supported an Article 5 convention for proposing amendments to rein in the federal government. Even so, we know that there are people on both sides of the aisle who are opposed to what we're doing. And some of them are under the impression that a convention of states would be dangerous. This fear stems from opposition claims that states can't be trusted to amend the Constitution. They contend that states might try to entirely replace the Constitution or scrap some or all of the Bill of Rights. Now, to put this in perspective, let's just imagine that you go skydiving with a friend, okay? You both get up into the airplane, you jump out together, and after free falling for a couple of minutes, you realize it's time to release your parachutes. So you reach back and you both pull that strap, but nothing happens. Parachutes don't deploy. You both panic for a minute and then you remember your training. You've got a second parachute in your backpack. So you reach back to deploy that second parachute, but your friend screams at you, "Don't deploy it, it's too dangerous." Confused, you look down at the ground, it's coming up very fast. You look back at your friend, you say, "The second chute is there in case the first chute doesn't work. It's for our safety. Do you have a better idea?" Your friend looks back and says, "No, but don't do it. It's too dangerous." Now, I know that sounds absurd, but that is pretty much what our opposition says about this effort. We, the American people, we're the parachutists, and we're faced with a very dangerous situation. Our federal government is literally bankrupting our country, among other things. And Congress is the first parachute. And if Congress were listening to we the people, they would propose reasonable amendments like a balanced budget amendment. But Congress refuses because Congress is part of the problem. Now, our second parachute is for states to propose amendments. Yet our opponents say, no, that's too dangerous. Do they have a viable alternative? No, but they're insistent on stopping us from deploying our proverbial second parachute. Now, we know from previous experience that in upcoming committee hearings, you're going to hear claims from our opposition that proposing amendments to the Constitution via Article 5 is too dangerous. At the end of the day, you're all going to have to decide what to do with that. Convention of States and the people who are testifying before you here today, we rely on a team of nationally acclaimed attorneys to help ascertain and confirm the safety of the Article 5 process. Two of our most prominent attorneys are Michael Farris, whom you've heard from today, and Robert Natelson. Since you already have met Dr. Farris, I will tell you about Robert Natelson. So he is a law professor of 25 years. His research has been cited repeatedly at the U.S. Supreme Court, federal appeals courts, and state Supreme Courts. He's widely acknowledged to be the nation's preeminent scholar on the Article 5 process, having written the only legal treatise on this subject. So I hold his book in my hand, The Law of Article 5. He is the author of no fewer than 40 articles on the Constitution in peer-reviewed legal journals. 5 of those articles were published just in the past 13 years, specifically on the Constitution amending process. Now, collectively, Michael Farris and Robert Natelson have written more than 300 pages. Okay, I have them printed here, front and back, 300 pages in legal journals over the past 13 years to specifically debunk claims from our opposition that somehow following the legal lawful process of Article 5 is too dangerous. Now, because these writings were peer-reviewed, they were rigorously evaluated by other constitutional experts for historical accuracy, 2 centuries of Article 5 usage, and a long line of Article 5 court decisions extending from 1798 to the present century. And so in conclusion, when you hear and read opposition testimony in the upcoming committee hearings, we urge you to evaluate their claims that following Article 5 of the Constitution is dangerous against the following 2 criteria. First criteria, are their claims simply statements of opinion, or have they been vetted by real constitutional experts through the peer review publication process of legal journals like the writings of Michael Farris and Robert Natelson? Criteria number 2, are their sources contemporary, meaning are they from this century? Put more simply, is their material outdated? This is important because our opposition likes to cite sources from the 1950s, 60s, and 70s, when activist judges and professors favoring big government made unfounded claims to stop states from amending the Constitution. If so, these claims have very likely been debunked by the 21st century scholarly writings of Michael Farris and Robert Natelson. So putting it simply, if our opposition can't get their provocative claims peer-reviewed by real constitutional experts and published in reputable law review journals, then I would submit to you that they're not credible and you shouldn't take them seriously. If you hold our opposition to these high standards, what you're going to find is that very few, if any, of their claims are worthy of your serious consideration.